Good evening. This is John Milburn for Laws 12067 Environmental Law. We've reached week 12 of term 3 in 2017. We're into February 2018, and this week is examination week. So on Friday afternoon, we will be doing something a little different to our usual routine for environmental law, and that is you'll be given a short window within which to complete your examination. The examination window from memory is 3 hours, and I'll run through some of the basics of that this evening. The task requires you to answer 2 questions, and you need to submit your work at the end of that 3-hour period. Don't leave it until the last moment. Make sure that you submit your work, otherwise you will get locked out of the system. All right, so more about that shortly. So what have we covered in this unit? What we've attempted to do is demonstrate how environmental law operates at different levels, I guess vertically and horizontally. Let me explain. From a vertical perspective, those of you that have studied law, and most of you would have, being part of a law degree, will be aware that we have the familiar trichotomy of Parliament, the executive, and the courts, the judiciary. So the separation of powers. We have that in environmental law that overlays the entire system. But within that system, we have different elements that apply. And most notably at the start, we have international law. We don't talk about international law in many other subjects. Maybe a little bit in family law, where we talk about the Hague Convention. We maybe talk about some issues in relation to international law in other fields, but it's not a strong point. It's quite strong in environmental law. So if you're answering a question in relation to environmental law, or you're dealing with an environmental law problem, you must always consider whether international law to some degree applies or not. So there are a number of different sources for international law. As you're doing your revision for the course, have a look at some of the databases, the websites that we've discussed, some of the treaties that we've discussed, and think to yourself, can these apply in a real life situation? Can they apply if you're asked to answer a question or advocate a cause on behalf of a group or an individual or a company or an organisation? Then, of course, from that we have the very real involvement of the parliamentary of legislation in terms of the Commonwealth, the state, and also council. We don't get that very, very often. In criminal law, contract law, we're not talking about the interplay of Commonwealth and state and council rules, regulations, laws in the same way that we do in environmental law. It's always a live issue. And in the second assessment, you've seen, of course, how there is that interlink between the Commonwealth, the government, and the state government in terms of the executive function when dealing with a large-scale application, in this case, the Townsville Port application. So we see it from the executive perspective. We then see it from the judicial perspective, in that the courts have different horizontal layers as well that apply in environmental law. By that I mean, apart from having its ordinary, if you like, function of determining, its determinative function, courts also have the increasing role of facilitating ADR processes. So when you're thinking about a litigation matter, you need to consider not only the operation of the laws, but the way in which the courts will operate. And when you think about the way courts operate, you must always think about issues to do with practice directions and rules. So, for example, we have the Planning and Environment Court rules, we have the Uniform Civil Procedure rules, and the rules and the practice directions work in conjunction with each other to provide clear guidance as to how litigants should be involving themselves in the process. So what I guess I'm saying, and it's taking a long way to say it, is there are many facets of most questions that relate to environmental law, and you must be mindful of those facets. And when you approach a question, the first thing to do is try to adopt a broad approach to it and think laterally, vertically, horizontally. There are usually many ways to approach a particular problem on behalf of someone. Now, Kim, did you have a question?
Yeah, John,
Yes.
I'm thinking what you were saying, like going vertically, like you're actually getting into my mind space now, like that's how I think. But when I'm looking at a, a case and I'm trying to get, a summary of what's happened and what the judgment was, I don't recall seeing anything about practice directions. Like, I don't know how that is that something that you've got to think outside of the circle to actually understand how a case actually works? Because, I mean, obviously it's statutory interpretation there at a 101 level, but I don't know, like, I've looked at all, like, going through that second assignment, and I can see the relationship with that in regards to regulations and acts, but in a case scenario, I don't see that being eradicated with any decisions, or like they don't seem to actually, with all the judgments, it doesn't actually seem to go back to that uh, statute, I suppose. Like, do you know what I mean? I'm dribbling a little bit of
No,
here at
I
the moment.
understand.
But
Well, look,
I'm trying to spit out the words, but I don't know how the practice directions has a relationship with a court ruling.
that's a very good question. And perhaps let me approach it this way. In terms of the assessment work that you have, if you think about it, I've worked backwards. So the first assessment called upon you to consider the way in which a court dealt with a dispute. You were looking at the end product. The court heard the evidence, made its decision, recorded that decision, put it in writing, and you now get to see how the court thinks in terms of it. What we didn't see, it's a little bit like an iceberg, what we didn't see is everything that led to get to that stage. So iceberg, I don't know, 90% underwater, hidden, 10% visible. You read a case, you see the 10% that's visible. You see the top. You see the final product, if you like. The hidden part, the bulk of it, you don't see. And it's within that bulk area that we started to move as we progress through the course. And this really comes into what you're saying, Kim, because the practice directions, the rules, the regulations provide a mechanism by which we ultimately, in litigation, get to the stage of having a case heard. You're not going to get your case heard unless you know how to deal with the practice directions and the rules and resolve all those issues on the way through. So just as a reminder on practice directions, and I will explain more about what I'm saying here, I'm just going to share the screen. I do hope that I get this right. Let's see. This probably will give us a page with practice directions. Please let me know if it's not. And oh, there you go. Zoom has been upgraded. Now it says Zoom is sharing this application on the actual screen.
Wow.
There you go. So that's
Fantastic,
a brand
John.
new thing. We got it right? All right. So here's the practice directions for the Planning and Environment Court. And last week we identified a few that were, I think, important for you to consider. And you'll be able to look at those. So if you have a question in the examination that requires you to make some comment about litigation procedures, you really must talk about practice directions, and probably you need to talk about case management procedures. You probably need to talk about alternative dispute resolution and perhaps the powers of the ADR registrar to make orders, issue directions in relation to dispute resolution issues. So, and you'll see that there's a note there that some of these important practice directions do change. So that's an example for practice directions in the Planning and Environment Court. The land court works in a different way. I'll just stop the share now.
Sorry, John. What?
Yes, Kim?
Sorry. So how do you apply that? How do you apply that? Because I don't see that, like, when you're looking through the court cases and things, and I'm probably, like, I've been out of law for a little bit to study, but you don't see that in the referencing. Like, you don't see that, like, that doesn't stand out, but, like,
No.
excuse
And the
French, like
courts,
dog's balls, because that should be, I guess, the predominant direction. But I'm not with you on how you apply the application.
sure.
Sorry.
No, and that's fine. So when I started tonight's session, I mentioned something briefly about the exam, but said we'll come back to it. And it'll become more apparent how we do that when I come back to talk about the examination techniques and what you might need to consider. But I can say this, that the practice direction mechanism is the structure by which we ultimately get to a point where we can achieve a court decision. But on many occasions, most occasions, any matter of litigation is resolved before we get to the court. So many more matters are caught up in the practice direction regime than the actual hearing of a matter, if that makes sense. But I take what you say, Kim, and I accept what you say, that you're not going to read the decision and learn much, if at all, about practice directions, because the court's not going to say, for example, that the parties complied with the practice directions and the case management guidelines. They filed their material on time. They participated in the ADR process. All of that's kind of taken as read. So the court won't give us that level of detail, which describes the process by which the parties came to be physically in the courtroom giving their evidence.
So, sorry, John. I don't mean to. Like, I mean, this is our last session, so I want to take every moment of your time if I can, because I'm not clear. So, if you're going to argue from a defence point of view or a prosecution point of view, could you not argue that those practice directions aren't being adhered to? How would you argue that?
Yes, usually that's a good question. Usually that's by an application within the cause. So ultimately your cause might be to advance a particular argument on behalf of a community litigant or a counsel or an applicant. And if the other side, if your opponent is not complying with the practice directions, you'd probably bring an application to say, we seek an order to compel the other side to comply with the practice direction number, whatever it might be, by attending an ADR process, or by preparing their affidavit material, or by having their expert attend an experts conclave. So those are, if you like, mini trials that deal with the issues of practice on the way through to ultimately hearing the matter. But you're not likely going to hear about that when the court comes to its decision. So I mentioned that we're going backwards because you started with, in the first assessment, the task of describing what a judge did in a particular matter, how the judge determined the matter, and what the judge thought was important. And from that, we then progressed to the second stage, and of course, thinking about what are the appeal points. So if you were to take it further. The second stage dealt with the administrative role of government, federal and state, in terms of a large-scale project. And now the third assessment is taking us right back to beginning stages to say, what would you do, how would you approach matters if you were asked to do so on behalf of one of two potential litigants? I won't tell you which of the two it is, but it's one of two. So that's what we're doing in the examination. All right, so where do you look when you're preparing your studies? Where do you go to do your research? Obviously, we have our textbook, which is excellent, but it's quite theoretical. So I've directed you to many websites, databases. Kim's right, you do need to consider your statutory interpretation principles when you're dealing with environmental law. Kim, I'm sorry that you haven't done statutory interpretation before you did environmental law. It's usually very much the other way around. But
I did, but the university didn't
oh
recognise my
yes, sorry.
core
Okay,
subject, James Cook University, which I don't know why, but you know, but I'm learning more, so I'm happy with that.
that's good. All right. So you need to consider when you're asking yourself a question about the legislation, do I need to consider explanatory notes or explanatory memorandum? Do I need to consider second reading speeches? If so, where do I go? And you'll need to be prepared because the 3 hours that you have for the assessment on Friday will go very quickly. So you want to have all these things lined up if you can. When you're looking at the databases and the websites, you need to consider what resources you have in our university library. They are extensive and you need to have organised that ready to go. A very good, important source of information is government websites, particularly if the examination that you have relates to enforcement issues. Then you may want to consider, for example, what the Environmental Protection Authority website says about a matter, or what a council website might say about a matter. So there are different websites that will help. If the question relates to community litigant, then you might want to consider some other types of websites like the Environmental Defender's Office. And of course, you have the familiar areas of legal research to consider as well. Okay, so in the final assessment, which is worth 50%, I'll just have a look at the unit profile. And it said in the profile that the task involved 4 things. The first is describing the basic structure, institution, key functions and process of the Australian legal system within which the environmental law operates. So you can see from that objective, the first objective of the final assessment was, I want you to know from a practical point of view, what are these basic structures and institutions? What is the vertical, the horizontal, the lateral? How do they intertwine? What are their key functions? And how does this whole legal system work within the context of environmental law? So you need to know your way around places. For example, if your question relates to enforcement of matters on behalf of a council, then you wouldn't say, oh, take this to a tribunal or a court and have the court or the tribunal answer the question. You're going to be much more specific than that. I'm going to say, what do I go to the family court? Do I go to the small claims tribunal? It doesn't exist anymore, but do I go to the QCAT's minor civil disputes jurisdiction? You know, where do I go? And when I get there, what do I need to look for? That's where the practice directions come in, Kim. But beyond that, because I want you to know the basic structure, the key functions and the process of the Australian legal system, not just the court system, I want you to be able to tell me something about how the executive function may have a role to play in all of this. And if your question relates to community litigants in the examination, you'll need to know on what basis can community litigants take action to enforce environmental laws. So that was Booth and Bosworth was our sample case in that regard. So it's not just a matter of saying, oh, you know, go to court and seek an order. It may not be that going to court is the best resolution. We talked about alternative dispute resolution. I've mentioned that a number of times, and you need to consider that. Right, so the second objective of the written assessment, when we look at the alignment of learning outcomes, and in fact, what I might do is share this so you can read it. Just bear with me a moment. If you've got your unit profile there, I think I'm looking at last year's, but I'm quite confident it's the same. So I'll just share the screen. So number 3, the written assessment, 50%. The second dot point was analyse major topics and key issues such as environmental property rights, access to and management of environment, environmental protection measures, and environmental litigation with reference to relevant sources of legal authority. Okay, a lot of things there that relate to this final assessment. So how do we deal with issues about the management of the environment? Who's in charge of managing the environment? What's their authority to act? What can they do? What options do they have? Do they only prosecute? Or do they take court action in different ways? If your question relates to what a council or a regulatory authority might do to prosecute, well, we think back to the first case we did, we can see what the council did there. And we'll know in the reading that the council did more than just prosecute. They tried a number of different alternatives that was referred to. And we know that there are a number of different ways that the management of the environment can be undertaken. So, but if we do go to environmental litigation, what is the source of legal authority and what are the orders that are available? Number 3, identify and respond to the types of legal problems and issues likely to be embedded in commonly encountered environment-related activities. Okay, I'm just going to stop the share here. I think at the outset, I indicated that when it comes to dealing with environmental problems, for the most part, they're one of 3 types. The first is that you're acting on behalf of an applicant in relation to a proposed matter. You're looking at a proposal, an application. In the second assessment, the proponent was large scale, but many of the cases that you read about in environmental law relate to smaller matters, and they're very closely aligned to planning law. So in that context, many of the applicants that you read are looking to develop something. They're looking to develop a parcel of pristine rainforest land to make it a subdivision, which is the Predijon case, which was the feature case that I used to use a few years ago. You may have seen some videos on that with Rod Lister QC. So what are the environmental issues that arise when you're acting for a proponent? An applicant. That's number 1. The second scenario is, how do you act for a regulator that seeks to enforce environmental laws? In the court context, we saw in the first case, it might be prosecution, it might be enforcement notices, it might be a whole range of different things. So what does the enforcement agency do? Or it might be a council, which is an assessment manager being dragged into litigation. So they can be the plaintiff or the defendant, the applicant or the respondent, the council. Now, the third type of litigant typically would be a member of the community. And that's, again, 2 types. It might be that someone has put in a submission about a particular application and they then are invited to join litigation because they have done so. Or it may be that it's a community litigant that wants to stop a wrong. They see something that's wrong and they want to know what's about. So I've made it a little easier for you in terms of your preparation. You know that the main problem, which is worth 35%, will relate to acting for and advising one of those 3 parties. We'll narrow it down to 2. It's either going to be that you're advising a council about enforcement, or it's advising a community litigant about enforcing environmental laws. Okay, so in fact I've narrowed it even more because both of those can act in different capacities. We've narrowed it down to one of those 2. So within the context of that examination question, I'm just going to share the screen again, and we'll look at the final objective in the unit profile for this written assessment, and that is to explain the environmental law litigation process and alternative dispute resolution procedures. So you must cover those things. and at least deal with them, at least acknowledge them, and talk about how these things could eventually become subject to ADR. All right, so the exam itself is in 2 parts. We have 3 hours for the exam. Part A is worth 35 marks. Part B is worth 15 marks. My comments tonight have primarily related to Part A, which is the more substantial matter where you're asked to advise either a council in relation to a complaint that a property owner has failed to comply with development conditions, or a community litigant to restrain someone or some organisation from engaging in conduct or an offence against the EPBCA. So I've really narrowed it down there. I'm always a bit reluctant to do that because I don't want you to gloss over your reading. The main objective here is to learn. Getting marks is probably secondary, I think. I really want people to learn, but I appreciate that marks are important too. So that exam is, that's for Part A. Part B, which is worth 15 marks, has a word limit, I think, of 500 words. And in that regard, it's really an essay question. So that can be from anywhere in the course, and there's no multiple choice, I'm sorry. You prepare your answer on the single word document. I would have my template ready. So before we even start, I would have your cover sheet ready. I'd have your formatting ready. I'd have, everything that you can possibly get ready in there. I'd actually go further, and I would have ready to cut and paste an outline of advice for either a council or a community litigant, so that you can then start to fill the gaps within that advice. You're not cheating if you do that. I mean, I've told you a lot of the detail of what's in the examination so you can become as well organised as possible. Okay, so if, for example, it's about a community litigant involved in trying to deal with an offence or contravention of the EPBCA, well, you're going to have the section of the Act that's relevant, you think, ready to go, and you might even have some commentary where you talk about that piece of legislation. If your question relates to a council dealing with a complaint that a property owner failed to comply with development conditions, you probably have something ready to go about when a council has the authority to deal with failure to comply with development conditions, maybe have something about the legislation, maybe have some cases organised that you can refer to as part of your authority. So why not take the opportunity during the week to be as well prepared for the exam as possible? I think you'll enjoy the process more if you do that, and hopefully learn as you go through. In terms of the essay question, as I said, I won't give any hints on that. That can come from anywhere in the unit. Although I did actually, no, I'm wrong. I will give you hints, and it's right.
You already did it. Sustainable development.
I did.
With Justice last week.
I did. I will give you huge hints. It will either be about ecologically sustainable development generally, or climate change and sustainable development. I've given you, I don't know why I'm so generous. I've given you so much.
You're just a great guy.
Yeah,
and you know what?
Is that it?
Created a whole world of pain because there's a lot of material out there.
Yeah, I know. There is a lot of material. So you can have your 2 answers pre-written if you like, and drop that in. But I want them, I want them to be good answers. So the more hints that I give you, the better I expect the answers will be. So there is a downside. All right. Are there any questions?
Yeah, just one, John. Sorry,
Thanks, Scott.
Wasn't able to write very fast, but you said one question may be the property owner failed to comply with the development conditions, and the other one was a community litigant seeking to enforce, and that's where I got. So were they seeking to enforce compliance with the EBPCA or seeking to remedy or seek some sort of remedy for an offence committed against the EPBCA?
Yep. No, it's a community litigant to restrain someone or some organisation from engaging in conduct that constitutes an offence or a contravention of the EPBCA.
Hey, John.
Yes, Justice.
How far should we go in citing the Sustainable Planning Act, which has already been repealed anyway? Yeah. So should we do that, or should we cite the Planning Act of 2016 instead?
Planning Act, please. So try to avoid the Sustainable Planning Act if you can. It's been a funny area because it's this changeover period, but if you can refer to the Planning Act, please do so. But it's unavoidable. You can't avoid referring to the Sustainable Planning Act in some ways because all the case law relates to the Sustainable Planning Act. If you go back further, it's the Integrated Planning Act. But where possible, the Planning Act. Thank you, Justice.
And John, just one other question with the submission of time. Like obviously you'll have to have a stopwatch or something, start at 8 o'clock and keep looking at it, otherwise you'll lose track. The only issue is going to be is you'll have everyone in the course submitting in like this 10-minute window. What if there's some issues with IT issues trying to submit at that time?
Look, everyone is welcome to phone me, and look, I may even set up a Zoom session so that if there are any problems, you can contact me. But I don't think there'll be a problem, given that so don't start at 8 o'clock because 8 o'clock will be too late. That's when you've got to submit the work. So Queensland on Friday, the 9th of February. This is Queensland time.
I know you got to remember New South Wales. We're down here. We're supporting you up there.
So Queensland time on Friday, the 9th of February. I will release the paper at 5 p.m. and it's due at 8 p.m. Now, there's probably, if I had to select a time when there's not a lot of Moodle traffic, it's probably a Friday at 8 p.m. So it'll just be, and there's 55, 60. So there might be some traffic, but it won't be huge. And if you really get stuck, let us know. The other thing is that if you're well prepared, I don't believe you'll need 3 hours for this. So if you finish it in an hour and a half, don't stress and think, oh, I've missed something. It probably reflects the fact that you're well prepared. So even though I'm giving you a 3-hour window, it's not a 3-hour examination. If I was setting a time, I'd make it 2 hours for this one. So you might be finished by 7:15 and knock off, upload your work. I hope that answers your question, Scott. But otherwise, please email or phone. You can phone me 0400 734 789.
You're a good guy. Thanks, John.
No, that's fine. Well, last night I was up quite a while dealing with exam issues. So I don't know. Yes, Kim?
Well, I was up, I didn't get to bed to 4 o'clock this morning, but that's not through study. So I understand sleep depreciation.
Yes, 4 o'clock's a bit hardcore. All right. So do you feel, yes, Justice?
Hey, John, I know you've said that we may not need 3 hours, but for a normal invigilated exam, we normally are given 15 minutes to browse. So does it mean that we won't need the 15 minutes to browse before we start the writing? Because, as you put it, you probably won't need the 3 hours.
Oh, you're a good negotiator, Justin.
Good try. You've done an amazing.
Really good. No, if I gave you no hints at all, then maybe I could give you the extra 15 minutes. But good try, Justice. But no.
You know what?
Having said that, maybe I'll release it a couple of minutes early. Yeah, sorry. Yes, Scott?
Yeah, just one you might want to block out that part of the presentation where you gave your mobile number, because if you upload it to YouTube, everyone in the world's got it.
Oh, it's on my website anyway, so it doesn't matter. That's fine.
You're a good guy. It's really funny that you should say that. You know what? I actually prefer to sit down to have a vigilated exam. I would
Yeah,
prefer to do that because there is absolutely no stress with the internet and technology, and environmental law is one of them.
yeah. No, that's true. There's a lot,
the
to be said for that.
environment just has so many changes, and like you
Mm,
can't deal with it. I'd
yeah.
rather sit in a good exam.
No, thank you for that feedback. And we are very keen to get feedback. So if you have not yet had your say, and I'm talking, I'm sure, primarily to those that might be viewing this after the event, please go to the top left-hand corner, push the big red button, have your say. It's very important for me and for the university. All right. Well, I think we're just about done. Are there any other questions, comments? All good? Scott's okay? Justice okay? Kim, all good? All right.
Thanks, John.
Enjoy your preparation this week. This is our last session for the course, for the unit. I will provide generalised feedback, but as you know, for the last assessment, there's no personalised feedback, and you'll get the results when you finally get your grade, whenever that might be. I forget the date. All right, all the best. Thank you very much.
Bye, John. Good luck. Good
Okay.
luck. Good luck,
See you
guys.
all,
Thanks,
Hope
guys.
everyone does well.
and have a great time in the exam. See you then.
Oh, great. That's just what everyone wants to hear, John. Scott.
You'll like it. You'll enjoy it. Bye then.
God bless. Bye.